And get started in just a couple seconds. Okay. Hello, welcome everybody to Legal Briefs. My name is Mike. I work here at the law school. I'll be introducing Professor Zacks tonight. Eric Zacks is an associate professor of law at Wayne State University Law School. His scholarship focuses on modern contracting practices and the relevance of behavioral and cognitive sciences to the legal and social construction of contract formation, breach, and enforcement. His work has been published in many law reviews and journals, and recently the second edition of Contracts and Context from Transaction to Litigation, the casebook by Professor Zacks and his co-author Professor Grossman, has been published by Aspen Press. During this program, Professor Zacks' talk will discuss his contract law scholarships, as well as the evolution of transactional law course offering at Wayne Law. Please join me in welcoming Professor Eric Zacks.
Well, hello, everyone. I don't know. I'm glad to see so many familiar names in the participant list and to see so many names, a few names that I don't recognize. But I always start my classes the first day of classes by introducing myself because I think my background is relevant to what I've been doing at Wayne State. I'm from the area. I've been at Wayne State almost 15 years, but I grew up here, and it's been very rewarding actually to teach in the community. I can't believe I've been here almost 15 years. When I joined the faculty, I had 3 children, 4 years and younger, and 15 years later, you know, the oldest is about off to college. So Wayne State has marked my children's childhood in a way. So and as life has changed, Wayne State has changed. And I'll get into the scholarship in a minute, but just to take an example in terms of career services, which are near and dear to my heart. I've been very active in that area, particularly, you know, given my ties to the area, but also just, you know, wanting to do right by our students. Career services has changed so much. When many of you know, went to law school, it was very passive. It was there were postings of jobs and good luck to you. And the model really has changed. I think it's reflective of what, you know, students are looking for, but also law schools recognizing that they need to do a better job. And it's really changed into a headhunter model where we get very deep into the data on each student. Due to unforeseen circumstances, I actually served as the interim dean of career services for a brief spell. And really the dean's vision, Dean Biersbach, who I have a lot of respect for, he really, again, wanted to do right by our students, which meant getting to know each and every one of our students, finding out what they wanted to do, getting the faculty involved to make reference calls, to see what kind of opportunities we could provide. And we always did well. Wayne State grads have always done well in terms of job placement, but we went from doing pretty well to a leader in the nation. We're top 20 in the country right now in terms of job placement with respect to JD required or bar passage required or JD advantage jobs, which is really a testament to the Office of Career Services and Professional Development. But really the dean's vision and something I had agreed with, and it's really been rewarding. We meet, just to give you an idea, about 6 months after all the students have graduated, the dean will meet, and I and the staff will meet once every week, sometimes once every other week, to go over every unemployed graduate, to find out what is going on, what more can we do, what alums can we reach out to, what networking opportunities can we provide. And that's the direction, I think, of law schools in general. If I can just sort of talk more generally, it's much more, students come in a lot more savvy with respect to what they expect out of law school, and law schools are willing to give it to them. So that has been very rewarding to me. So before I got into some of the scholarship things, I just wanted to say that's something I've been heavily involved with for the past 7-8 years anywhere. I've been, again, chairing the faculty committee for career services, and then my involvement every year with them in terms of trying to place as many of our graduates as we can. On the downside, I'll just say as commentary, the students that don't get placed generally are the ones who don't respond, and it's that, you know, there are some students who, even in this day and age, will will ghost you, and that's something you deal with. And it's hard to believe that some folks graduate without a social media presence, but we have trouble. We track them down as best we can. So and it's no holds barred on that. So with that, the transactional law offerings has changed as well. A lot of what we're trying to do now, students also want more skills-based training. Law firms and other employers want to see graduates coming out with more job ready. And for me, it's less about being ready to practice in transactional law or in any other area of law, but it's about having gotten exposure. I think one of my regrets through law school was you really didn't have a good idea of what it was like to practice as a lawyer. And the curriculum has really changed, particularly in the transactional law area. There are more skills-based courses. So in addition to, for example, our business law clinic, we have a corporate counsel externship where students can intern for credit at different corporations. And now we're looking at law firms and so on, in addition to a classroom component. And we have a lot more skills-based competitions. So there's a health law competition, there's a sports law competition, there's many others that students get involved with. But for me, what's near and dear to my heart, and we're coming up on the 10th anniversary of it, is the transactional law competition, which started, again, really almost 12 years ago. We had a group of students who wanted to compete in a negotiations competition. And they asked, I had seen it pop up, Drexel was running it. We began participating in that competition. It was so great that we brought it in-house to Wayne State. So it basically involves, as some of you know, I see some alums on the, alums both as students and also alums who have volunteered to serve as judges. Really takes students through a mergers and acquisitions transaction. We partnered with Jaffe, now Taft, and they've underwritten the program. And as a result of this, and I'll talk a little bit about more what's involved, we've conducted almost 1,000 different negotiation rounds at this point. So basically 1,000 deals have been negotiated in the past 10 years, which is really exciting to me. That's what it's about, is providing that glimpse, even if you're not building your skills up that much, which you should through the program, but just to get an exposure to what is it to be a transactional attorney. I know that when I applied for my internships at Miller Canfield and Jaffe and Honigman and all the different places, I said, well, I wanted to be a transactional lawyer, and I was making stuff up because I didn't know. Law school did not prepare you for what does it mean day in, day out to be a transactional attorney. So I came up with a few nice phrases about, value adding and, counseling clients and things like that. And I didn't know what I was talking about. No one in my family was an attorney. I didn't know, but I just knew I didn't want to be in court. So I had to find a way to not be in court. So transactional law it was. And so really what we're trying to do is provide a safe space. The competition is offered as an intramural competition, Wayne State only in the fall. We have anywhere from 25 to 50 students that participate each fall semester. They're divided up into teams, and they're tasked with amending an existing purchase agreement. So the purchase agreement is already there, and they either have to represent the buyer or the seller, typically with respect to a problem that has arisen prior to the deal actually getting done. So that involves a number of different skills, as you all can imagine, drafting. We have an opportunity to ask client questions. Even that, just to sort of go talk about that for a minute, what kinds of questions you ask clients, right? They learn quickly. The client won't answer legal questions, even though they think they need to ask legal. Well, do you prefer to, Delaware or Michigan law? Well, why are you asking me for? I'm the client. I don't know. That's what you're there for. And trying to get really guidance from the client is an important lesson, right? From business counseling, would you, finding out where your squeal points are and things like that. So I love the process. We do a number of, I do a number of lunchtime presentations to sort of explain the background of a transaction. Many of them have not necessarily taken mergers at that point or finance. So we walk them through the different stages of the transaction, giving them the background, but it's largely given to them. And one of the reasons I like it is it's given to them much the way it is in practice. You're given an assignment and good luck. And this year we had alums who acted as the senior partners that they could go to with questions, but for the most part, they're on their own. So they have to come up with finding how to use precedent, figuring it out. What does indemnification mean? Most of them don't know, for example. So, and that sort of hands-on learning, as we all know, that's the best type. I firmly believe that, and the students, and I tell them this, and they agree. They get in what they put out. So we'll get out of it what they put in. Sorry. For example, you get a pass-fail course. You could get through it. You could skate through it and not necessarily work very hard. But the students who go on, and I look at my alumni group as I look back at the chairs, the folks who have won the competition, and the success that they have enjoyed. They really credit, often in no small way, the transactional law competition. So I'm really pleased with, 10 years, 1,000 rounds. We're going to be doing something special in the fall to commemorate it. And I can't say enough about, our partners at Jaffe Taft. They've actually hosted the competition in the fall, the last couple of years. And this year we've actually expanded. We now host a national competition. So I think there's some information about that in the link, but we have the last couple of years, we've had 15 to 20 schools coming into the Detroit area. It's a great student networking opportunity. It's a great, just getting to know people in the field, to show off our city, to show off Wayne State. And it's really been a great experience. And I think it's really serving Wayne State well there also. So really excited about what we've been able to do in really a short amount of time. And lastly, it's all student run. So this program, I'm there and I take credit for it by being the opening speaker when we do the competition. But the students who win our competition, they typically, if they're 2Ls, the following year, they'll chair it. And they're responsible for everything. So logistics, and I actually even think for them, project management is a significant transactional skill, right? Where a lot of us corporate lawyers, we don't actually know that much, but we can manage a process and we can see it through to the end and make sure all the third-party tasks are actually getting done and running down, that sort of stuff. So really appreciative of all the competitors and the chairs, and really enjoy the program. It's when people ask about my teaching style, it's really about the way I wish I'd been taught, or by teaching the way my best teachers taught me. And thinking about what I want to know. And it's less about the retention of the doctrine, right? A lot of us don't retain a lot of what we've learned in class, but it's the exposure and getting a sense of what it's really like. And I try to do that in my classroom as well. I'll talk a little bit about that if there's time, but I did want to talk a little bit about my current scholarship. So sort of a natural segue is the casebook, which my co-author prefers to call it textbook, because we really are moving away slightly from the traditional casebook structure, which everybody thinks is just a very little bit of intro and here are the cases. And again, sort of a lot of hiding the ball. Our approach is really the life cycle of a contract. If you just read a casebook or went through a full year of contracts in many classes, you might not have ever seen a contract, and you might only have seen contract issues come up in litigation, which in 95% of the cases, that's not how contracts actually exist or are relevant in the real world. They're not off. Once they're executed, they're often not referenced. They're put into a drawer. They're only referenced for performance purposes. Many disputes are not in litigation. So that private ordering that takes place was really missing. It's missing in, I believe, really in virtually all casebooks. People will say, oh, my casebook is transactional. But what they mean by that is they'll fix the glitch. They'll say, oh, what happened in this case? Oh, something went wrong. Well, we'll just draft better next time. That's transactional. That's not transactional. Transactional is finding out why your clients are interested in a transaction, why they might want to enter into a relationship, thinking about in a real world sense, what can go wrong. So in our casebook, we start at the very beginning and we give them the parts of a contract and say, here's what a written contract typically looks like, and here's why. And here are some sample problems and simulation problems. And you have to think about what types of provisions you would want to put in there. Sure, it's very rudimentary discussions. They're not learning how to draft, but they're getting an idea of what transactional lawyering is about and why these things play out even in litigation the way they do, right? What was the misunderstanding up front that might have led to this? So our casebook, really the first half is that pre-contract formation world, and not in a doctrinal sense. It's thinking about due diligence. It's thinking about asking the right types of questions of your client. And again, in a we have a simulation problem that runs throughout the book in addition to practice problems. But one thing I like to do in my classes is the students are divided up into groups, and each week one of them is responsible for posting a video of themselves advising the client in response to the prompt. So, and again, these are transactional problems typically. The back half of the book, yes, there are videos relevant to the litigation, but for many of them, this is the first time they're advising a client in a transactional context. So similar to the transactional law competition, we're trying to, again, give that exposure and start thinking prospectively with respect to relationships. What can go wrong? How do I protect my client? What questions are they not thinking about? Becoming someone who can ask good questions. We often say, if it doesn't make sense to you, then you should ask the question, right? Because your client probably hasn't thought it through if you've got a question about something in a term sheet or the nature of the relationship that they're entering into. So really excited about the second edition of the casebook. We've changed a lot. We've changed quite a bit about the layout. Our casebook is very expository. We don't try to force students to discover the law through Socratic or hiding the ball sort of case method. The doctrine is out there for you. We lay it out. We discuss it and we apply it, and we go through cases to look at how it was applied, but we're not trying to hide the ball, right? We're saying here are the rules on formation, on mutual assent and consideration. Now let's play with it. Okay, we're not going to discover this way. They're going to get plenty of that in other classes, how to discover doctrine, that sort of thing, and figure out what the rules are. But we'd rather spend time applying it in again, real life practice problems. So I'm excited about the second edition, and again, continuing to use it in my classes. I have to warn my students ahead of time when they're in my class, what we're doing, you're not going to hear in your other classes, and it's going to be different. You're not going to be hearing, even in other contract sections, you may not be doing the same thing, right? And that's okay. But we're on a different mission here, and we've done surveys and we've gotten an overwhelmingly positive response. I'm happy about it, and I'm happy about what we've been able to tweak in the second edition. A little bit about my scholarship. I did start off with a lot of cognitive science sort of findings, thinking about the way you could strategically draft. Not just, and there's a lot of literature, and many of you are familiar with that, about how to strategically draft to take advantage of consumers, right? So that's a very well-plowed ground. What I wanted to think about is how folks could draft to take advantage of other players in the contract world. So the first would be the judge. So how can you prepare a contract so as to get the best, the judge sort of seeing the best picture for you. So less about the terms themselves, but how you present them. So maybe you might want to have somebody initial something 10 times, not because it actually matters, but if I have to show it to the judge, hey, look, they initialed it, that's relevant from how's the judge can interpret that. Oh, you initial it 10 times, you must have read it, even though empirically we might find that most consumers don't. So thinking about judge response, and even thinking about the other contract parties themselves, how do they act after the contract is entered into? So not at the time of formation, how do you design a contract to sort of, I don't say take advantage because it's just such a pejorative, but to just strategically, how could I draft a contract for my best benefit? But after the fact, when the other party is not happy and they go to read the contract, how can I deter them from trying to enforce the contract, right? So maybe I'll put in things in there that push the envelope, that are in the gray area, that'll deter them from not enforcing the contract against them. So to take a relatively recent example, there's a lot of literature about why people don't walk away from underwater mortgages, right? And so part of that is there's a lot of there is this sort of norm, you pay your debts as when they come due and things like that. But economically, in many instances, people might have been better walking away from their mortgages, but they weren't. It was unlikely they were going to be pursued by banks and so on. But maybe something in the contracts was relevant there too, right? How can you, we're going to come after you, here are all the bad things that can happen to you in your contract. So to the extent that the contract is a reference point at any time, not just formation, how can it be drafted in a way to exploit others' cognitive biases? More recently, I've looked at the other end of the spectrum, sort of fully negotiated contracts. What are the limits of private ordering? And specifically, the current article I have, it'll be published in the next year or so in one of the journals that accepted one of my first pieces, the University of Pennsylvania Journal of Business Law. But it's about contract and fraud and the increasing practice among mergers and acquisitions attorneys of trying to compartmentalize fraud. So in many mergers and acquisitions agreements, parties agree to certain limitations on liability. So no matter what happens under this deal, you can't sue me for more than 10% of the purchase price or a dollar figure. You can't sue me for more than $1 million. One of the exceptions, and there's a lot of varieties, I'm not going to go into all of them, but fraud is acknowledged as a general exception to all of those limits. So whether you've limited it by dollar amount or by time period within which to bring claims, fraud is an acknowledged exception. So in a fully negotiated deal, there may be a lot of representations and warranties that are actually in the agreement. And the last thing a seller wants is to be sued for fraud, period, but also for something that might have been said or discovered prior to the closing. So how have they dealt with that issue? So over time, right, people use robust integration clauses. So this is the entire agreement of the parties, nothing I said before, but fraud is an exception to that. Well, maybe I can have the seller disclaim any other reps and warranties outside the agreement, right? Seller's not making any representations or warranties other than those in the agreement. Well, the buyer might still be defrauded. The buyer might still be relying on things outside the contract. So maybe we need the buyer to promise not to rely on anything. Even then, maybe there's fraud by omission or fraud by concealment that we might want to deal with. So increasingly, parties are trying to define what fraud actually means in their contract. So again, if you think about that, how extreme that is, we're saying there's this doctrine out there, fraud, that's an exception to our limitations on liabilities. And we're going to say in this private agreement what it actually means. We're going to say that fraud only means if I personally, and not my employees and not my officers and not anybody else in the world, but only if I intended to defraud you with respect to what's in the agreement. So not only am I limiting, we're sort of defining what my intent has to be. I have to intend for you to rely on these specific statements, but it's only on the statements in the contract. And my fraud cannot be, the fraud of others cannot be attributed to me. So there's, again, pros and cons to allowing that sort of private ordering. Fraud is not, everyone acknowledges that fraud is bad, right? That we shouldn't encourage fraud. What's interesting in this context is really we have what some have referred to as the double liar scenario, double liar situation. Two people are really lying here. The seller arguably has lied with respect to some fact, right? The fraud that was outside the contract, arguably, maybe they misled the buyer in some way. They made a false statement. But the buyer's also a liar here. The buyer also is lying because the buyer is saying in the contract, I'm not relying on anything in the contract. And now, oh, something went wrong. Now I'm going to say that I was relying. So you have this, well, which liar do you choose to win? I talk about in the article, not about what the limits are, or should there be any limits, right? So in a situation like a merger where the buyer and seller are free to negotiate for whatever representations, warranties that they want, why can't a buyer go in eyes wide open and say, I agree not to sue for anything that happened outside the contract, even if I acknowledge you may have defrauded me with respect to something outside the contract? So I explored that issue. And then I think, what I hope with this article to show is how different this situation is from the consumer context, right? The consumer context that I've sort of worked in up till now is a much different scenario where consumers do not have the ability to negotiate for better protection. Nobody is competing on representative warranties relative to consumers. They can't go out and get a better representation from a different seller in many situations. So that's continuing to explore that. I actually did a little bit of work in mortgage foreclosure work, talking about how contract law was changing as a result of the number of foreclosures that had to be brought. I was fortunate to partner with my brother on that, who's a foreclosure defense attorney, who was very prominent in the robo litigation issues that came up over time in that context. So professors, we're always looking for the next project, and we're always looking for the next idea to write about, and we sort of sink our teeth into these projects, and we chew them until we're just sick of them, and we're done, and we have to find the next project. And as I sort of look back, going into looking at career services, doing a case book, looking at consumer law, looking at foreclosure law, looking at M&A law, transactional law competition, and now directing our LLM program. I'm excited about the next chapter. And I guess, but the last thing I will say is that when I came to Wayne State, and this is, we tell this to everyone who interviews, the best thing about Wayne State is the students. It's easily my favorite thing. And that's just been true. I've been so gracious, so generous, so hardworking. I've just been fortunate to work with so many of them. We actually, the law school hockey team had a game last night. They let me play since I agreed to be the faculty advisor. So I don't know if that's a positive or a negative, but just such great, open students, and so happy, so grateful to the extent you meet them halfway on anything. And it's really been the best part of my experience. I don't ever want to do any sort of presentation relative to Wayne State without plugging our students, because it's really been the most rewarding part of my time at Wayne State. You can't let professors have open mics, so I'm going to stop there, because again, that's just dangerous. So I'll stop. I don't know if there were questions that came up during the chat. I'm happy to elaborate, of course, on anything, but.
I'll just ask a question. So how long was it between your first and your second edition? And when do you begin working on the second edition of a textbook prior to it completion?
It's a good question. I think it was published in 2019, but it took us a good 2.5 years, I would say, to put it together. Revising the second edition. So we do it when they tell us to. It's in the publisher contracts. It was a great conversation. I've told this story before, but they tell you, we know your contracts law professors, but this is a take it or leave it contract. You can't negotiate it. So they can tell you when to do the second edition. You need to do it. It took us I think it took us a good year to do it. We take notes as we go. We actually were fortunate to have an unpublished version of the manuscript that we used in the fall. So I was able to get notes from our students. I did that the first time when we first published it too. We had an unpublished manuscript, which I think was beneficial for both. The students got a cheaper casebook, and I got the feedback from the students, and I gave them participation points for pointing out typos and providing substantive comments. So it took us about a year. My co-author is fantastic. At this point, other than 1 or 2 chapters, I can't tell you which chapter she initially wrote or I wrote. We just have the same voice. It's really been a nice collaborative process. She reached out to me, actually. She had was familiar with some of my work. We had a similar transactional background, and as soon as she said I'm doing a transactional book, I said yes. So
If anybody else has a question, you can feel free to put in the chat, raise your hand, or just go ahead and unmute yourself.
No questions, but just want to check in and say hi.
so great to see you, Chris. How are you?
Yeah,
Good to
great
see you.
building. Yeah, thanks.
Yeah, I keep track of you on LinkedIn. So
Yeah, you as well. We'll see the business law thing this next fall, hopefully.
yeah, I hope so.
Probably a pretty hard-hitting question for you here, Professor Zacks. Hockey team win last night or what?
Yeah, we lost in a shootout.
Oh, that's rough.
It's actually, it's a good system.
Well.
Yeah, at least it's a good system though. At least they if you tie, they do go immediately to a shootout, which a lot of beer leagues don't do. So but you know what? Our jerseys are the best jerseys in the league. So we've got the Wayne logo on there. We got officially licensed products. So we look pretty sharp. So in a still picture, we look pretty sharp. How about that? So
Well, it's great to see you. Great to hear about all the cool things you're doing at Wayne. Glad to hear you're doing well.
Appreciate it. Same here.
Okay, if there's no more questions, Professor Zacks, do you have any closing words you'd like to provide, or?
Only, I for this at a lot of at the end of my classes as well. If there's ever anything I can ever do for any of you, whether or not you were a student of mine or not, I'm happy to be a sounding board, happy to be a reference, or just to make introductions, or to talk about careers. I find the due diligence in your career is just as important as the due diligence on a transaction, right? Finding out where you want to go. If there's anything I can do, I hope all of you will reach out, whether or not you were one of my students.
Awesome. Thank you so much. And thank you everybody for coming tonight.
Appreciate it. Thank you.
Yeah, great. Thank you, Eric. Appreciate it.